Hello everyone and welcome to today's webinar. Don't let the banker write your estate plan. I'm Kim Browning and I'm excited that you're here today for this topic because it affects nearly every family. Yet most people don't fully understand the risks of it going wrong. This is part 2 in our Dirty Dozen webinar series, which are the top 12 estate planning mistakes that you need to avoid. We want this to be educational, informative, and engaging. So please feel free to use the chat feature and ask questions. And to get everyone comfortable with this feature, let's start with the scenario that you might recognize. A banker, an advisor, or a friend says to you, just put your kids as co-owners on your accounts, or add your oldest child to the deed to your house. It avoids probate. Type yes or no if you've heard this advice from someone. Sounds simple, right? Let's get you engaged here. All right, I see some people putting in here yes. All right, well, relying solely on beneficiary designations and joint account holders without a will or trust can work sometimes, but in most cases, it comes with significant risks, especially with regards to probate. Even though it might avoid probate, it can change your estate plan. So if someone dies without a will and you don't have a revocable living trust, the distribution of assets must follow the intestacy laws, and probate oversees that process. Today, we're going to go over the 7 major risks when you rely solely on beneficiary designations on your joint accounts. We're going to go over real-life examples of families who got it wrong and how you can avoid those mistakes. The first key risk is unintended errors. Unintended errors. The people who receive through the probate process. So even if most of your assets pass through beneficiary designation ownership, assets that are not titled correctly or without a beneficiary have to go through probate. This includes real estate that's not jointly owned. It includes personal property, the cars, your collectibles that you have in your home. It includes bank accounts without designated beneficiaries on them. And it can include digital assets or intellectual property. So the state intestacy laws determine who gets these assets, which might not be what you intend, might not be in line with your wishes. Here's an example. Maria has her son, Jake, who lives with her and cares for her. She might have intentions to leave her property to Jake, tells him, Jake, when I pass away, you're going to receive the house, but she never takes the steps to put together a plan. So when she dies, the house has to go through probate, and we have to follow the intestacy laws. Maria has another child, a daughter, and under the intestacy laws, both children will split the house evenly. Again, most people think that probate just means a lot of paperwork, but it really causes delays and it has costs that people don't anticipate. The typical time that it takes for a decedent estate to go through the probate process in Michigan is a minimum of 6 months. And oftentimes, if the estate contains property that's difficult to move, such as a home, it can take up to 2 years. The costs that are involved are court fees, just getting the process started, even if you do not retain an attorney and prepare to do it yourself. The court costs up front can be difficult to front because you don't have access to the bank accounts. So you have to dip into your own pocket, sometimes $500 to get the court documents filed. You have to publish to creditors, which is the publication fees over $200. And then if you do have to retain an attorney, attorney's fees are thousands of dollars. Then eating into the cost of the estate is the fiduciary fees. The person who's appointed as the personal representative can charge fees against the estate, and typically they do, normally around $40 an hour. So that the fiduciary fees in some cases can really chip away at whatever the final estate is valued at. So these costs reduce what heirs ultimately receive. So probate is expensive and time consuming. Another example is David dies, $300,000 in assets. Some of them are in joint accounts and some of them aren't. His car, we all live in the Motor City, and a lot of people are car people here. If your car is valued certainly at $100,000 or more, you'd certainly want to put that in some sort of trust. You don't want to take it to chance as to who's going to fight over it. But in this situation, David's car, some of his savings accounts don't have co-ownership. He's got no will, he's got no trust. So they go through probate. The court fees, attorney's fees, filing expenses are nearly $20,000, and the process takes 15 months. One of his daughters is in needing of assistance to get through education for college, and she's had to wait over a year to get the money. So it has, in addition to the loss of her father, she has had to put aside her personal goals in going through school because she wasn't able to receive the money that she needed to continue her education until later, just because of the lack of planning. The lesson number 3, the assets falling through the cracks. So even if you set up some beneficiary designations, what happens with the assets that you forget? The assets that are not properly titled or designated have to go through probate. An example, and this happens quite frequently, especially with elderly individuals. When you have husband and wife, usually the accounts are jointly held. Usually the husband who has retirement accounts name the wife as the primary beneficiary, and then if either one of them passes away, if the account isn't retitled, if the beneficiary designations are not updated, then that account could go through probate. So in this particular example, Eleanor listed her son as the beneficiary in her retirement accounts, but forgot to update her brokerage account when her husband passed away. There was no beneficiary listed, and then there was no will put in place. This asset had to go through probate, and there was a huge delay in the son receiving the benefit of the account. Key risks number 4 are legal disputes. When there's no written will, there's no expression other than verbal as to how you want to divide your personal property, or quite frankly, how you want disputes to be handled. For instance, you can send your family to mediation before going to court. The family conflicts, the legal challenges are more likely. Here's an example. Bob passed away having a third wife and 2 children. The joint checking account he shared with his third wife, and under the operation of law, she becomes the owner of that account. Bob had a life insurance policy. He listed his daughter as the beneficiary, but he verbally told his son, who wanted to receive this cabin, this hunting cabin that he and his son had many, many memories at, said, I'm going to make sure that you get the cabin. You're going to get the family cabin when I pass away. But he never put it in his will. He never changed the deed. So after Bob's death, the third wife and the daughter, because of the intestacy laws, can claim stake in the family cabin. And his son also got into the mix of the litigation and then started contesting the claim to the joint account because it was done close to his death. And Bob's wishes were completely not followed at all. Risk number 5, there's no control over minor or special needs beneficiaries. Now, this is one of the most serious problems that can arise. You know, people certainly don't want minor children to receive assets, and most people don't understand the consequences when you have minor beneficiaries who are receiving. I have many clients who, you know, don't think about or don't expect to pass away, but then they have their minors who are going to receive the assets, and it actually adds another layer to the probate process because a court must appoint a conservator. And then sometimes a beneficiary might have special needs, might be receiving state benefits that could be disrupted. And then you have spendthrift heirs who might waste the assets relatively quickly. So a trust in this type of situation is a necessity. A trust is going to protect those that are at most risk here, the minor beneficiaries and beneficiaries who have special needs. An example is Jane names her 10-year-old son as the sole beneficiary of her $150,000 life insurance policy. This really happens. So a court in this situation must appoint a conservator to manage the money until he turns 18. The conservator might not be the person who Jane intended to manage the money either. And without proper supervision, you know, this is going to cost the state more money. It can cost a lot of issues with the minor beneficiary trying to receive the assets. Dealing with special needs children. Unfortunately, clients who want to cut corners and just have this type of planning where they want to just name beneficiaries without putting together any formal trust or will, they think that disinheriting the special needs child is the best way to go about things because they expect other family members to go ahead and step up and provide for and manage the money. That doesn't always happen in the best interest of the person with special needs. Through disinheriting the special needs child, the special needs child, you know, could miss out on the money itself because the person who receives the money, who is supposed to take care of the special needs child, isn't legally obligated to take care of, to do the right thing. And the special needs child who's disinherited is going to continue to rely solely on SSI and Medicaid benefits. All right, so we don't want to disqualify the special needs child from the means-tested benefits such as SSI and Medicaid, but there are better ways to do it. You should do this by establishing special needs trusts. Okay. The special needs trusts that can be established are, it's called a third-party special needs trust, and it's part of your individual planning that you put in place. And the special needs trust can hold funds that can be used for the special needs individual to provide for housing, education, medical care, recreation, transportation, all of the things that the child isn't going to receive through the programs such as SSI and Medicaid. So a parent who passes away without proper planning with special needs children, disinheritance leaves the child very vulnerable. The direct inheritance will disqualify them for their means-tested benefits, which you also don't want to do. So please, 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 anyone who has any friends or any relatives that have special needs children, make sure that they do go see a qualified estate planning attorney to be able to put in the right special needs trust for them. Risk number 6, outdated designations or ownership structures. People think that they're going to go to the banks, they're going to go to the financial custodians of their accounts and update the beneficiaries when major life events happen, but it's something that gets put off by many people. Examples for life changes are divorce, when you remarry or marry for the first time, or when your spouse or significant other or other family member passes away. An example is Michael names his ex-wife. Well, he's been married for 10 years. He had his wife as beneficiary of his IRA, never changed it. When he passes away, his adult children are shocked to find out that she still gets the money because beneficiary designations override the default inheritance laws. People seem to think that the whatever it is that they put in their will override the beneficiary designations, and that isn't the case. But in Michigan, IRAs and other accounts, there are special rules that are put in place for people who specifically get divorced and don't update their plans. If there's no law or court order that intervenes in this case, the ex-wife will receive the IRA, even if it wasn't his intention. So the children are kind of out of luck if you don't update that. But Michigan, not like every other state, but Michigan specifically has a law that revokes, it's called Revocation on Divorce Statute. I have the citation here. And it addresses this specifically, that a divorce automatically revokes any disposition or appointment of property, including beneficiary designations made by a divorced individual to their former spouse in a governmental instrument. So a will, a revocable living trust, a life insurance policy, a retirement plan, or other contractual arrangements are revoked automatically with the divorce decree. Okay, so in this situation, the IRA might be completely revoked, his prior beneficiary designation. But there's another loophole to this, and that is the federal law preemption on ERISA plans. So when someone goes through a divorce, they really need to make sure that their divorce decree it includes what's called a quadrel, Qualified Domestic Relations Order, that will address this because the federal law will preempt what the Michigan law states. Okay, so I kind of get into a lot of detail here. So bottom line, in Michigan, divorce often revokes beneficiary designations, but there are important exceptions. To avoid probate and unintended results, update all your beneficiary designations immediately after divorce. Review your divorce judgment to ensure all assets are aligned, which includes the retirement accounts. Create or update your will and or trust after all major life events. And here we go, consider ERISA plans separately because they're not always covered by state law. And then now we're at the key risk number 7, lack of asset protection and planning. When you just use beneficiary designations and you transfer assets to the beneficiaries, unlike a trust, joint ownership, and beneficiary designations, they offer no estate or creditor protection for the heirs. Here's our example that Sam left his son $200,000 through a transfer on death account. His son was in the middle of a divorce and he had credit card debt. As soon as he received the funds, guess what? The creditors came out of the woodwork, sued him to collect any outstanding balances. His ex-spouse claimed a portion in the divorce proceedings, and he's out of luck. If Sam had the funds in a discretionary trust, they could have been protected by both. And a lot of my clients do this. They make sure that the beneficiaries, their children who would receive their inheritance, that it's not going to be lost in a divorce and it's not going to be spent right away if there are issues, creditor issues. Even if someone's in jail, there's restitution fees that could eat into the estate. So being careful and being cautious about the creditors that your family members or the people who you want to receive your inheritance, sometimes you're not even aware of the issues in their lives. Some people don't, they're not that free of speaking about how much debt they have. So just taking the precautionary steps and making sure that you have a discretionary trust for your beneficiaries, for your heirs, can certainly give you peace of mind. All right, so beneficiary designations, we've been going over all of the key risks and what the problems are. So when might this actually work for people? When can you just go ahead and put beneficiary designations on things? Well, when the estate is very small. And this is, when we've got people who are just starting out in life, they just are graduating from high school, they're going away to college, they have just a little bit of money. So when the estate's very small, they can put beneficiaries on their accounts. They can put transfer on death, mom and dad, sister, brother on their joint account, on their accounts. The assets are properly titled with payable on death transfer and designations. This is through the banks. You can do this directly, as well as life insurance policies. Make sure that you have beneficiaries and contingent beneficiaries on them. And of course, when there's no real estate, when there's real estate, you absolutely need to put a plan in place. Also, when the heirs are few, they're cooperative, and there's no minors involved. Relying on beneficiary designations and joint ownership might avoid probate, but only if everything's perfectly aligned. So keep all of this in mind when you're reviewing your individual assets. A comprehensive estate plan, including a revocable living trust and a will, provides greater protection, flexibility, and peace of mind for you. So a summary table of what we just discussed, of the 7 points that we hit on. The first is you can have unintended heirs. And here we have the example where the cabin, the hunting cabin passed to the third wife. A lot of people don't realize that if assets do go to probate, you know, the intestacy laws that we talked about, your spouse can inherit because there's a protection. Even if you think that you disinherited your spouse, they can still take against the will. Your will can say, I don't want to leave anything to my spouse. If the assets are going to be distributed according to the will, the state of Michigan allows the spouse to receive their spousal elections. And that can be quite significant. And it can be a surprise to all the family members. So you have unintended errors, delays and costs. Probate costs can exceed $20,000 and take a lot of the family member's time. Assets that fall through the cracks. Here the great example is husband and wife have their brokerage account, and once that brokerage account goes to the surviving spouse, that surviving spouse, especially if they're elderly, sometimes passes relatively quickly and doesn't get a chance to put their beneficiary designations on the accounts. Legal disputes, verbal promises leading to family fighting over the property. Minors and special needs beneficiaries are especially vulnerable. And then we have outdated designations. We have ex-spouses inheriting IRAs. And the lack of asset protection, you have spendthrifts who are going to spend the money, or they have creditors who are going to put their hands out there and receive the inheritance before your intended beneficiaries do. So final thoughts. We want to make sure that your estate plan is a comprehensive plan and not just a patchwork of joint accounts. And you don't want to set up your family for confusion, costs, and conflict. You know, you're not going to build a house without a blueprint, so please make sure that you get your plan put in place to avoid probate entirely. Protect those vulnerable beneficiaries, keep your family conflicts at bay, and save your loved ones lots of time and stress and money. So thanks for joining us today. I'm going to open it up to questions. Anybody have any questions they'd like to put in? Okay, I have one question here about the joint accounts and creditor issues. Okay, so this is something that we kind of touched on, but we didn't take a deep dive in. So when you do have, when you're setting up your joint accounts, a lot of times you have husband and wife who own a bank account, and that's great. And then when you do add daughter or son to your account after your spouse passes away to avoid probate, your children's creditors do become your creditors. So that is another reason why you want to avoid just adding people to your accounts. An example is if your daughter is now a co-owner of your bank account, and if she gets into an automobile accident, is sued, and her insurance doesn't cover the full claim, then you know the recovery of that lawsuit, then they can actually go into and tap into your joint account, because as a joint account holder, that's available to her creditors. So yes, that is another good example as to why you don't want to just rely on joint accounts. If you do want a son or daughter to have access to your account for purposes of avoiding probate, certainly use the transfer on death or the payable on death designations to the account. And if you're adding them onto your account just so that, you know, for the reason of them retaining control over your account if you become incapacitated, well, in that type of situation, you want to use a general durable power of attorney, which they would then be able to present to the bank and gain control over your account during your lifetime to manage your account during your lifetime if you need that situation. So that was a good question. Any other questions? I don't see anybody. Nothing else in the chat. So today's lesson, don't let the banker or the courts write your estate plan. Take control now, protect what matters most. Okay, we want you to call or email us today for a consultation. And we want you to join us in 2 weeks for part 3 of our Dirty Dozen series, which is going to be you may not keep score, but your kids do. So this lesson is on fairness, equality, and family conflict and estate planning. So thank you, and we'll see you next time. All right, bye-bye.